Hello guys, welcome to this channel. My name is Mary Maura. I'm an advocate of the High Court of Kenya. In this channel, we discuss all matters law without any discrimination. So if these are matters that interest you, please stay tuned. Now, it is said that childbirth is an act of nature, while adoption is an act of God. I'm a true believer of this statement because I believe that every child deserves a right to a stable home and a family that is full of love and selflessness. Kenyan law has strived to make sure that the best interests of a child have been taken care of, and with the promulgation of a new Children's Act 2022, there comes a detailed program of how adoption process should take place. Now in Kenya, there are three types of adoption. The first kind of adoption is known as the kinship adoption. Now, the kinship adoption is where a person who desires to adopts their relative. Now, the second kind of adoption, we have the local adoption. Now, the local adoption, the adoptive parent and the child are both Kenyan citizens. Now, the other form of adoption is known as the foreign adoption. It occurs in the following three instances. First instance, a situation where an adoptive parent is a Kenyan national and a national of another country, which is to mean dual citizenship. The other person or foreigner who can adopt a child is a foreigner who is biologically related to a child that is residing here in Kenya. Now, the other one is a situation where, as a Kenyan citizen, you relocate to another country, and then by operation of law of the country you have relocated to, you lose your Kenyan citizenship. The law still allows for you to adopt a child. I believe that the Kenyan law is directed towards the best interest of a child, and that is why it is very keen to ensure that children are not locked out of having to grow up in stable families and stable homes. Now, even before I get into the nitty-gritties of the principles of adoption, it is imperative that I make these three statements. The first statement is that you cannot adopt a child who is 6 weeks old or less. Then the second statement that you have to grasp is that a male adoptive parent can only be allowed to adopt a blood relative. So sole adoption for a male adoptive parent is restricted to blood only. Then the last imperative statement that you should know is that Kenyan law does not allow for preselection of minors. So you cannot walk into any children's home in Kenya, point out a child and say, I am going home with this child, and if I'm not going home with this child, I do not desire any other child. So the only circumstances under which you might be allowed to pre-select a child, one is when the child is your kin. And the second part is where you have been fostering this child. What I mean by this is that you have been staying with this child for a period of like even 5 to 10 years, in which case now it is considered that moving this child from your home to another home is not in the best interests of that child. So, as we have stated, that a child can only be adopted upon attaining 6 weeks old of age. There is other criteria that is looked at in order to consider a child eligible for adoption. So the first instance is when this child is an orphan and they have no parent or guardian who is caring for them. The second instance is an instance of abandonment. This is a situation where a parent or a guardian has continuously abandoned this child for a period of 1 year. Then that child automatically becomes eligible for adoption. Now, the other instance in which a child is eligible for adoption is an instance in which the parent of a child decides to willingly give up their parental rights to the adoptive parents. Now, I believe that if you love someone unconditionally, then you do what is best for them and not what is best for you. And sometimes, in as much as it is hard, you have to come to a point where you accept that this child is best placed under a stable home because the environment I'm in right now is not in the best interest of a child. Now that we have looked at the eligibility for child adoption, let us now look at the part of the parent. For you as a prospective adoptive parent, what are the qualifications that you need to have attained? The first one is you must be between 25 years to 65 years of age. And the other requirement, you must be at least 21 years older than the child that you are adopting. Now those are very simple facts for your own understanding. Now, there is an exception to that rule, and this is in respect of kinship adoption. So in cases where the person you're adopting is your kin, then the age limit does not apply to you. Now, let us look at people who cannot be allowed to adopt a child. The first kind of person who cannot adopt a child is a person who is deemed to be of unsound mind. What this means is that this person cannot manage themselves and they cannot manage their affairs. So the second kind of person who is not allowed to adopt a child is a person who is deemed that they cannot take good care of a child. Then the other kind of person is a person who has been convicted of sexual offenses, corruption, of indecent assault, which causes serious body harm, especially children of 16 years and below. Then also people who have been convicted of crimes of fraud and forgery, people who have been convicted of human trafficking, they cannot adopt a child. Now, the other person who shall not be allowed to adopt a child are two people who are unmarried. So if you two are unmarried and you together you want to adopt a child, please know that the Kenyan law will not allow you to adopt a child. The other kind of person who cannot adopt a child, as we had stated earlier, is a sole male adoptive parent who are seeking to adopt a child who is not related to them by blood. Then in cases of foreigners, the only child you can adopt is the child that you are biologically related to. Now, there are instances in adoption where consent is needed, and in other instances, consent is not needed. So, consent is required in cases where it is the parent or the guardian or a person contributing to the maintenance of a child is giving away the parental rights to an adoptive parent. So they need to write a consent to state that they are agreeable to giving up their parental rights to the adoptive parent. So the other person who can give consent is a child who has attained the age of 10 years. They shall be called in chambers and they shall be asked whether they desire to stay in the adoptive home. And if they agree to that, then that consent shall be recorded. In cases where such a child has a disability or an impairment that would render them not capable of giving such consent, then assistance is done and the child is explained to. Then consent shall be recorded after the child understands that they are being adopted by a certain person. The other consent that is required is in a case where a person is married, but they desire to adopt a child by themselves without involving the spouse. Then the spouse's consent is needed, except in situations where the spouse, they are separated. So if they are separated, then the consent becomes dispensed with. Now, sometimes the court shall dispense with the need for consent. And this shall be done especially in cases where a parent, a guardian, or a person who is contributing to the maintenance of a child maltreats that child and abandons the child. Here in Kenya, there are very many orphans who are taken care of by relatives, but the conditions these children are living in, my goodness, you will be shocked. So in such circumstances, the court shall not require the consent of such a person. Now, the other situation in which consent can be dispensed with is a situation where the parent, the guardian, or the person who is contributing to the maintenance of the child cannot be found, and they have been looked for a period of 1 year and they can't be found. So in such cases, the court will dispense with the consent and they will just allow for the adoption process to continue without any interruptions. The other situation is a situation where the parent, guardian, or the person contributing to the maintenance of this child is not giving their consent for no good reason. So you find their relatives who they have abandoned children. At the same time, whenever someone shows up trying to adopt this child and give them a stable home, you find such relatives, they say that they will not give consent. So the other option is where the person who is contributing to the maintenance of a child refuses to contribute or declines to contribute the maintenance for a period of 1 year. So a consent can be unconditional or conditional. So an unconditional consent is where the parent, the guardian, the person or the child, they give consent to and say, okay, I agree to be adopted, or I agree for you to adopt this child. But sometimes there are conditions. For instance, I'm a Christian. Should I desire to adopt a child whose religion is Islam, then there shall be a condition that I will be required to take this child to the mosque for madrasa. The religious persuasion becomes a condition. Now, for consent can either be oral or written. Oral in the sense that the consent giver shall be called to court to give evidence and to assure court that their consent has been given and the extent to which this consent has been given. The other option of written consent is where the consent giver goes to an advocate or to a judicial officer and tells them that they have given consent. We have come to the end of part 1 of this adoption video. In our next video, we shall be discussing the process of adoption, all the way from when it starts in the adoption society, all the way through court, the adoption order, and what happens after the adoption order. Thank you so much for sticking up to this point, and I hope to see you in the next video.